My name is Salil Tripathi. I'm the Senior Advisor for Global Issues at the Institute for Human Rights and Business. And I'm going to be speaking with one of my friends, Anita Ramasastry, who is a professor of law at the University of Washington. But besides that, she has been on the UN Working Group on Business Human Rights. And in the business and human rights community for over a quarter century, she has made significant contributions to her academic writing and advocacy. What we are going to do today is that at IHRB, the Institute, we run a course with Rafto Foundation for Human Rights, which is based in Norway, and the University of Bergen, which is, of course, in Bergen. And we offer it at the master's level every fall or every autumn. And the northern autumn, that is otherwise it's spring in Southern Hemisphere at that time, between September and November. And what we do is it's a program over a 4-weekend period. It's about 13 days in total, where we divide it such that the first and the final weekend can be in person if you choose to. Otherwise, you can take the entire course online. And what we're planning to do today is give you a glimpse, a kind of a curtain raiser of the kind of issues that we end up discussing, dissecting, and investigating and examining during this course. So over to you, Anita.
Great. Thank you so much, Salil. And it's my pleasure to have this dialogue with you today. I think what we need to do is there's a lot of focus today in 2025 on business and human rights and evolving legislation, mandatory human rights due diligence, the EU directive that may come into force soon. But we really need to step back. And as you mentioned, you and I have been working in this field for quite some time, for decades really, is really where did this come from? What is the origin of business and human rights? And in fact, actually, we didn't used to speak about it as business and human rights. So Salil, did it start here in 2025 or even in 2011 with the UN Guiding Principles, or do we need to go back further?
We need to go back quite further. And you could actually argue that the story is as old as the pyramids, because forced labor was definitely used by some business people who were financing and supporting the pyramid, or at least the slavery where modern corporations were using a very nefarious practice of enslaving people and bringing them to work in sugar plantations and other plantations. But let's look at the modern corporation more seriously. Then I think we have to go down to some of the critical issues that have come up. And one of them, of course, we have to think is the role that the certain German companies played during the Second World War. That's an important landmark where companies were saying that they were following orders and actually being complicit, a word which we keep coming back to in this field, in business and human rights abuses. And after that, of course, the story picks up. In 1984, there was a major disaster in India, which was the Bhopal gas disaster, which is something worth keeping in mind. And all of this is in the backdrop of the resistance that has grown against colonization, because even the 18th and 19th century colonization, if we look at it, they started with trade. Companies were being at the forefront. East India Company, the Dutch East India Company, were going to different parts of the world to trade, and the trade led to conquest and colonization later. But we were talking about the Union Carbide theory, large multinationals operating in a country with lax standards, and what happened in that kind of a situation, and the resentment that started growing against transnational corporations at that time. And then there were some critical incidents, such as what happened with the oil companies in Colombia, in Indonesia, and the Niger Delta, which created a lot of resentment against companies. So business and human rights is a fairly old story. Now, I had a question for you, that when you start thinking about the modern business and human rights movement, where does that come into being?
Great. Well, thanks, Salil. I think, again, if we move fast forward just a little bit, as you mentioned, I think the issues of decolonization and the fact that multinationals took advantage of colonization moved into many countries in the world. And then when the colonizing countries left, the multinationals stayed. So there's this larger context of the power of transnational corporations and who is it benefiting, in which we have to situate business and human rights. But in the 1990s, with the rise of the internet, we were actually able to see, I think, more in real time, the connection between multinational corporations that might be located in what we call the global north, but Europe or North America, and workers who are somewhere else in the world, let's say in factories in Southeast Asia, and the harms or the conditions in which they're working in, sweatshop labor, for example. And so with the rise of the internet, we were able to look into global supply chains or look at what's happening with mining activity in some other part of the world and see the connection, right? That you have workers or people who might be harmed by transnational business and supply chains who in their own countries don't necessarily have access to courts or remedies for the harms that companies are connected to. So that is the beginning of the modern business and human rights movement. But I want to pause and say we didn't use that term business and human rights. In the 1990s, we used the term corporate accountability, that civil society groups that are representing workers, rights holders, victims, really speak about holding corporations to account, right? That they're making profits in different countries, but they're not helping or addressing the harms connected to their business activity. And so that's where the story began. So, Salil, I talked about the visibility of harm, right, in the 1990s. We also have sort of globalization, right? So global trade is increasing and is being liberalized. But there's also another story, and you started to talk a little bit about this, which is about lawsuits, right? That there's the power of these lawsuits that are an attempt to hold corporations to account. So maybe you can talk a little bit about this, in particular, the case of Ken Saro-Wiwa, as well as situations of conflict in places like Burma and Myanmar.
Sure, of course. That's a very good point. And you use the term corporate accountability. And one way that victims and victims groups and rights groups felt they could bring about some accountability is to use the law, because the companies don't operate in a complete vacuum or a legal vacuum. After all, there is the need for law, and there is a need for some kind of mechanism to hold them to account. And there have been many lawsuits on companies, and sometimes successful, sometimes not. Very often they tend to get settled out of court. But one of the main cases that came up was, of course, the execution of, and first of all, the campaigning by the Ogoni people against Shell, the large Dutch oil multinational in the Niger Delta, because the communities felt that their land was being degraded because of continuous oil pollution, and the security forces that were guarding the oil installation were using disproportionate force against the people who were protesting against it. And then there was a fake case launched against Ogoni elders, including Ogoni leaders, including Ken Saro-Wiwa, and he was executed along with 9 others in 1995. That galvanized a movement. And there have been lawsuits about it against Shell, not necessarily the Saro-Wiwa case, which of course was also litigated in another form in the United States under the Alien Tort Statute, but also other cases have happened out of it, and compensation has been paid in courts rulings in the Netherlands, for example. But there have been other important cases too. There have been cases against Chevron, there have been cases against Newmont Mining, and so on in various parts of the extractive sector. We have had those cases. And you mentioned Myanmar in this case, which is also a critical case here, because again, in Myanmar, Total and Unocal, 2 large oil companies, were operating there, accused of using forced labor, and cases were filed. And of course, finally, they were settled out of court. In the Unocal case was settled in the United States, and the Total case in France. And now on conflict, there are 2 very important cases going on. One is being tried in Sweden against Lundin Oil, which was operating in Sudan, and the other is being tried in France, which is against this large cement company called Lafarge Holcim, which was operating in what is called the Islamic State in parts on the border of Syria.
Yeah.
So looking at that, and when we look at all these different events, of course, one way to get the companies to hold to account is the litigation. Anita, would you say that this led to consciousness among companies and leading to greater conversation about business and human rights?
Yes, it did. So again, I think if we're sort of looking at the timetable, when we get to the 1990s, we start to speak about corporate accountability. And then we have these lawsuits, right? The lawsuits, as Salil, you rightly mentioned, many of them were against oil and gas or extractive companies because they were engaged in intensive investment in countries that were often fragile or in conflict. And so they really highlighted again this transnational, what we call governance gap, that you have victims somewhere in a country who can't get access to justice or remedy because they're in a conflict zone, they're in a country that's oppressive where there's weak rule of law, and then you have the connection to the multinational. So we talk about transnational tort litigation. Well, how does that nudge us forward to the modern business and human rights movement? Well, as you mentioned, right, the lawsuit against Shell, or the cases, right, were part of a larger advocacy. So litigation is one tool that we're going to look at, for example, in our course, but it's really about what else can we do? What are the techniques? So the larger issue here is, of course, companies up until this point were really asked only to uphold local law, right? Wherever they're operating, if they have a subsidiary or a business contract with the factory, local law is what matters. And local law is often not very protective of human rights, right? You might not have worker rights. You might not have environmental protections somewhere in the world. So the question is, could we raise the standard by which companies actually have to do business? And this is where human rights advocates started looking at the international human rights movement. Because again, the question was, yes, you can hold corporations to account, but you can't sue all of them. So like, what standards or what are we going to do? And this is where I think, again, the human rights community started to say, okay, companies need to do more than comply with the law. Let's try to look at how we can ask them to actually use international human rights standards as a level playing field wherever they operate. That's a challenge because I just want to sort of say that, international human rights law is about treaties primarily, and treaties are negotiated by governments that we call states. And who's bound by them? Well, government, states, right? So how can you actually translate that requirement into something for companies? And that's what the business and human rights movement is about, is making that jump and that leap. And so, Salil, maybe you can talk a little bit about a colleague that really was important in this field, David Petrasek, who helped us make that leap.
Yes, David was brilliant in clarifying our thinking about it because he had noticed the trend. Two things that happened, right? You had Amnesty International writing reports on Shell and Nigeria and Sudan, and so was Human Rights Watch writing these brilliant reports. And what to do with them? Naming and shaming was one way that the NGOs wanted to move forward. And some of the forward-thinking companies started adopting codes of conduct and principles. And these were what they call, we have voluntarily adopted this measure to deal with this issue. And they said, trust us because we have these values. And what David noticed that, yes, those values were good as a starting point, but they were not sufficient. And he came up with this phrase, and he came up with this wonderful volume that he had helped edit, the International Council for Human Rights Policy, called Beyond Volunteerism. That upsurge was anticipated at the end of the Cold War by Kofi Annan, who was the Secretary General of the United Nations at that time. And he made a famous speech at Davos at the World Economic Forum, where he said there is a need for a new global compact. Again, these were so-called voluntary standards in the sense that he wanted companies to adopt these 9 principles, which later became 10 principles. And the first and second principles dealt with human rights there. One was that companies will respect human rights, and the other was that they will not be complicit in human rights abuses. And that became the starting point of more and more companies signing up to them. But as soon as they signed up, remembering what David Petrasek was telling NGOs at that time, NGOs started saying signing up is not enough. Where is the proof? Where is the evidence? We need reporting. And which is exactly the situation in which people wanted to look at more. And there was another thing that was happening at the same time. And there used to be the subcommission of human rights at that time, where there was another David Weisbrot, who was a representative there. And he started working with NGOs, with certain companies and academic institutions to create what he called the norms and on responsibilities. They were draft norms, so draft norms on responsibilities of transnational corporations and other business enterprises. So it was not restricted to national, but all kinds of companies, state-owned, purely domestic companies, and so on. And he wrote those norms. But I recollect, Anita, and you will recollect that those norms were become somewhat controversial. Can you tell us why were they so controversial?
Yes, thanks, Salil. And I would say again, if we're looking at our timeline now, we're now moving into the late 1990s into the early 2000s, right? So as we see the progress, and of course, Beyond Volunteerism is something I think everybody should read because there was a world before the guiding principles, and Beyond Volunteerism really helped us get to where we are today. But as we go back after Beyond Volunteerism, we see as this next move at the UN Human Rights Council, or the subcommission at that time, these draft norms. And the draft norms were basically a restatement. So David Weisbrot, as a noted human rights professor, worked with governments and civil society and others, right, to create this document that took a large number of human rights treaties, so many different kinds of treaties, not just a sort of core set, and created this list and said, shouldn't companies follow them? And we're talking about everything from the Universal Declaration of Human Rights to the WHO infant breast milk formula code, right? I mean, just very different ones. And saying, as a matter of, norms mean kind of voluntary, right? Companies should look at their behavior and try to comply with all these standards. But what was challenging about the draft norms, I think, are two things, right? First of all, a lot of the corporate lawyers who started looking at this may never have taken a course in human rights, right? So it was a little bit overwhelming to see 20, 30, 50, I can't even remember how many now, codes and guidelines and treaties they were being asked to suddenly think about in terms of corporate compliance. The second piece was that treaties or norms or any kind of UN document has a preamble. And in the preamble, it stated that while the norms might not be binding at the moment, the goal was that they would become customary international law, that they would actually become binding. So the document was perceived as something that was going to become binding rules. And the question was, well, who says, right? Did companies negotiate this? And I would just say that again, it wasn't a sort of fully participatory sort of stakeholder process. And so the business community and large economies were like, wait, whoa, what, right? So I think it's just a lot of different things. Now, the UN doesn't kill things in the same way that we might, right? It's not about sort of, it was just that they were tabled, right? Shelved. And so the question is, once they were shelved, was there any momentum to do something further? And that's where we go from corporate accountability into finally that last part of the 2000s where we get to business and human rights. And so, Salil, how do we go from the norms to BHR, business and human rights?
Right. So, as I mentioned earlier, we had the Global Compact, which had come into being, which was running parallel at the same time. And many companies preferred Global Compact because it didn't ask them to do much. It created the floor from which they had to start working. But actually, as we see later, what Kofi Annan did was something else. After that, he appointed his own Assistant Secretary General, John Ruggie, who was an American professor at Harvard, to start developing what he said, identify and clarify the standards. We've had these norms which became controversial. We have the Global Compact, and you become the Secretary General Special Representative and identify and clarify the standards from international law and national norms that apply to companies. And he started examining that, and he looked at he did a survey of about 65 to 70 reports written by organizations like Global Witness, Amnesty, Human Rights Watch, ICJ, and so on. And after that, he started consulting. He did consulting in all parts of the world with NGOs, with companies. He went to mine sites and he spoke to lawyers. And he tried to come up with a framework. And the framework he developed, and that became part of the mainstream business and human rights movement. It was not just about accountability, but it looked at human rights as an essential part of business. And sometime earlier, Amnesty International UK had published a document, Business Human Rights, is it any of your business? So they started being seen together. And also the other important thing was that it was not simply what is called corporate social responsibility, but there was something more than that, corporate responsibility. All these terms started coming into vogue. And Ruggie came up with this framework on that, which were called the UN Guiding Principles. And what the guiding principles did was to come with three-pillar approach, that the state had the responsibility to protect rights. No one should harm somebody else, and that is state's response. But companies had a responsibility to respect rights. And then when there is a gap between, there is a need for a remedy. Now, companies thought that this is a get out of jail free card, because it. But that was to come up with a definition of what the respect means. And when they talked about what the respect term means, that's where he comes up with notions which became very important, such as due diligence and the need to have a policy, to implement it, to report on it, and then when there are gaps, to create a grievance mechanism. And what I was trying to get at is that this is where we pick up in our course, right? And this is where really drill deeper into it.
Yes,
right?
that's right. So we do, but I think our discussion today is really showing that there's a rich history of the business and human rights movement that predates the guiding principles. So the world didn't begin, or the business and human rights movement didn't begin with the guiding principles. And the reason this is important is because, again, we've already talked about that there are a variety of tools and approaches to dealing with issues of corporations and human rights that still exist today that predate the guiding principles. So we talked about litigation and transnational tort litigation, criminal investigations, right? Those things were tools developed much before the guiding principles. Similarly, human rights advocacy, naming and shaming. But I just want to mention a couple of other things too. We've talked a little bit about the fact that in the 1990s, just as we are today, there was actually quite a lot of conflict going on in places like Colombia and the Democratic Republic of Congo, Sierra Leone, violent conflict, Sudan. And so the business and human rights movement actually grew up in a place of business, human rights, and conflict. And out of that came things like conflict minerals legislation. So some of the tools of actually asking companies to look at where they were sourcing from comes from the world pre-guiding principles. Similarly, the world of what we call multi-stakeholder initiatives, which still exists today. It's a lot faster than legislating or negotiating a treaty to actually create what's called a multi-stakeholder initiative, which is civil society, business, and sometimes governments working together to create a sort of flexible code or set of principles that companies will adhere to, and some kind of enforcement mechanism to ensure that they adhere to the code. Whether these work is a different matter, and of course we talk about that. But the Kimberley process, for example, is one of the earliest ones, right? Blood or conflict diamonds in the late 1990s, right? Where you have governments, the major diamond companies, De Beers, and civil society trying to create clean, conflict-free supply chains. Similarly, we had the Fair Labor Association in the textile space. And I'd also say, as you've mentioned, we still have the Global Compact today. We have codes of conduct. And in fact, the whole concept of due diligence as a tool, even that predates the guiding principles. In fact, there's another multi-stakeholder initiative called the Voluntary Principles on Security and Human Rights, and it introduced the concept. Now, Ruggie and the guiding principles elaborate and create many new things, but just to say we need to go back before we can go forward. So, Salil, tell us what the course is all about. What else will we be talking about?
Right, we begin with the past. We certainly talk about the history of business and human rights, how they came about, and cover the kind of stories and examples that we talked. But one of the two unique features are there about the course. One is that we have a lot of corporate practitioners coming and speaking. So we've had companies like Rio Tinto, Anglo American. We have had bestseller H&M, and companies like that telling us what actually it means to implement due diligence on the ground, telling stories. Even Norwegian companies, Equinor and Telenor and Hydro, have come and spoken about some fairly serious dilemmas that they have faced, how they've handled. Meta also has been coming to the course to speak about their experiences. We have had corporate lawyers such as Ray Lindsay, who speaks about what due diligence means in practical terms when lawyers require you to do it. We have academics such as you and Erica George and others who talk about accountability from a legal perspective and take it beyond the due diligence mechanism and see beyond that. Academics also like Mark Taylor and experts on that who talk about complicity and conflict. We've had former officials of the ICRC, the Red Cross and Red Crescent, talking about humanitarian law. And another unique feature is that we have defenders like Nemo Bassi from Niger Delta and Frank Mugisha from Uganda, who talk about what oil has done to the communities in Niger Delta. And in Frank's case, he runs the Sexual Minorities in Uganda group, which is an NGO which fights for gay rights and which is a very hostile environment there. And he's fighting a very brave battle there, and how he works with companies to advance this cause. Because it's not that we are only talking about the negatives. There are lots of good things companies can do. And we have many examples of actions that companies have taken in supporting the human rights framework and advancing the cause. And then we look at the future, what lies ahead and what we can anticipate from that. So it's 4 rich weekends, 2 in person and the otherwise all 4 virtually, in this wonderful Norwegian town that we do with the Rafto Foundation, because Rafto Foundation does a lot of work on human rights defenders, and they bring us these great defenders. The student body includes corporate people, lawyers, and also defenders and activists. So it's a fairly rich experience, and I hope that you look at our websites, both of the Rafto Foundation, of the university, as well as the IHRB. Look at the course, consider attending it, and maybe we'll see you in this wonderful Norwegian city, Bergen.